Now going to the impeachment judgment clause. The strongest evidence against former President Trump's claim of immunity is found in the words of the Constitution. The impeachment judgment clause provides that the judgment in cases of impeachment shall not extend further than to removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. That language limits the consequences of impeachment or removal and disqualification from office, but explicitly preserves the option of criminal prosecution of an impeached official according to law. Former President Trump agrees that the impeachment judgment clause contemplates and permits the prosecution of a former president on criminal charges, but he argues that only that such a former president first must be impeached by the House and then convicted by the Senate. In other words, he asserts that under the clause, former presidents enjoy immunity for any criminal acts, violations of Congress, committed while in office unless he's first impeached and convicted by Congress. Under this theory, he claims he's immune from prosecution because he was impeached and acquitted. If the clause requires an impeachment conviction first, he may not be prosecuted. But if it contains no such requirement, the clause presents no impediment to his prosecution. Former President Trump also implicitly concedes that there is no absolute bar from prosecuting assertedly official actions. And he agrees that if he had been convicted in the Senate in that impeachment trial, he would not be immune from prosecution from official acts at issue here. He thus concedes that a president can be prosecuted for broadly defined official acts, such as ones alleged in the indictment, under some circumstances, that is, following an impeachment conviction. The impeachment judgment clause is focused solely on those who are convicted by the Senate following impeachment by the House. The second part makes clear that the limited consequences of impeachment do not immunize convicted officers from criminal prosecution. The party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. In former President Trump's view, however, the word convicted in the second phrase implicitly bestows immunity on presidents who are not convicted, based on a negative implication. He asserts that the impeachment judgment clause presupposes that a president is not criminally liable absent a conviction in the Senate. Other courts have rejected this tortured interpretation of the impeachment judgment clause, which previously has been advanced to support claims of judicial immunity. Former President Trump's interpretation runs counter to the text, structure, and purpose of the impeachment judgment clause. To begin, former president's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant immunity, and they did so in many instances. So I'm now going to talk briefly about the speech or debate clause being one of the immunities provided explicitly by Congress. Yet, they chose not to include a similar provision granting immunity to the president. The text says nothing about non-convicted individuals, non-convicted officials. Former President Trump's reading rests on a logical fallacy, stating that if the president is convicted, he can be prosecuted. Does not necessarily mean that if he is not convicted, he cannot be prosecuted. Impeachment judgment clause contains no words that limit criminal liability. And to the contrary, it uses nevertheless to ensure that liability will not be limited even after an official is impeached, convicted, and removed from office. The text of the impeachment judgment clause reflects its purpose to allocate responsibility between legislative and executive branches for holding impeached officers accountable for misconduct. So the court is saying that look at the purpose for which the impeachment judgment clause was written. It's a very textual reading. It's a very historical argument that this court makes. And I'm sure it takes into consideration the originalist, textualist, and ultra-conservative Supreme Court, which may get to review this case should they take the case. And they're making this argument by saying that the text and the purpose of it was not what Donald Trump is using it for. Going back. The framers chose to withhold such broad power from the Senate, specifying instead that Senate could impose only political, not ordinary criminal punishments. The framers wished to make clear that a president would still be liable to prosecution and punishment in the ordinary course of law. As the Office of Legal Counsel noted, that second part makes clear that the restriction on sanctions in the first part was not a prohibition on further punishments. Rather, those punishments would still be available, but simply not to the Senate. To counter the historical evidence that explains the purpose of the impeachment judgment clause, former President Trump turns to one sentence written by Alexander Hamilton in Federalist 69. The President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, of other high crimes and misdemeanors, be removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. He focuses on the word afterwards and suggests that the president is not liable to prosecution and punishment until after he has been impeached and convicted. But we think the more significant word in Hamilton's statement is liable, which means subject to. Hamilton specifies that a president would be subject to impeachment, trial, conviction, and removal from office, and afterwards would be subject to prosecution and punishment without regard to the verdict in the impeachment proceeding. Moreover, in the very next sentence of the same essay, Hamilton stresses that the president must be unlike the King of Great Britain, who was sacred and inviolable. The Federalist 69, that's part of Federalist 69. It strains credulity that Hamilton would have endorsed a reading of the impeachment judgment clause that shields presidents from all criminal liability unless they first impeached and convicted by Congress. In drafting the impeachment judgment clause, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that the subsequent prosecution would not be barred. Another founding fathers, Joseph Story, explained that the impeachment judgment clause removed doubt that a second trial for the same offense, could be had either after acquittal or a conviction in the court of impeachments. Story explained that without a criminal trial, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. Finally, the practical consequences of former President Trump's interpretation demonstrate an implausibility. The impeachment judgment clause applies not just to presidents, but also to the vice president and all civil officers of the United States. Thus, his reading would prohibit the executive branch from prosecuting current and former civil officers for crimes committed while in office, unless Congress first impeached and convicted them. No court has previously imposed such an irrational impeachment first constraint on criminal prosecution of federal officials. Even if there is a textual basis for treating presidents differently from subordinate government officials, as former President Trump suggests, his proposed interpretation would leave a president free to commit all manners of crimes with impunity so long as he is not impeached and convicted. Trump's interpretation also would permit the commission of crimes not readily categorized as impeachable. Under the best reading of the impeachment judgment clause, a former president may be criminally prosecuted in federal court without any requirement that he first be impeached and convicted for the same conduct.